I've been coming to India for about 20 years, firstly working with Hindustan Lever and then ICI India, and then latterly in private practice with many friends and clients here. And I've seen a huge number of changes over the last 20 years in India, both in general terms, but also particularly in IP terms as well, and one of which has been an increasing sort of willingness to look outwardly and to engage in a constructive fashion with the international IP scene. In Europe, things have been relatively sort of static for one reason or another, and now we've got our own little toy to play with. So there's going to be plenty of changes, potentially at least. So, by way of overview, we've got a proposed new system that will happen. There's far too much political capital that's been invested for it, so clearly not to, and we're at a very advanced stage with it. Under the proposed new system, there will be a single unitary patent for the European Union. Now, what that means is that it will be a single patent application that applies after grant for all European member states that sign up to this. At the moment, Italy and Spain are not signed up, but what will happen in due course with that remains to be seen. There are a number of advantages that are advanced as to the reason for this, and one of them is that in obtaining a patent in Europe, you need, at grant, to then decide which countries you would wish to take the patent forward in, and there are certain requirements, one of which is to file a translation and to appoint attorneys in each country, and then to pay renewal fees for each of those countries. So it can become quite an expensive business, depending on the technical sector that the case is in, and for high-value cases filed extremely widely, it can get up to many tens of thousands of euros. So the single unitary patent is intended to deal with some of those issues. Now, the Unified Patent Court is the second limb of this, and that will have exclusive jurisdiction on questions of infringement and validity of European patents. And part of the rationale for this is that it will enhance business certainty because you'll then have a single decision on the unitary patent across Europe. There are many examples over the last few decades where there have been patents that have been litigated in one country and the decision's gone one way, and then in another country and the decision's gone another way, and then the appeal body in the first country has thought, well, hang on a moment, perhaps this is wrong because in Germany they said something different, so at least there's an issue to be tried. So there's been, in some cases, a high degree of confusion. But it's not often the case that you have multi-jurisdictional patent litigation, so having a system that is intended to address a particular problem that arises, but only arises in a minority of cases, that is where you have multiple actions on the same patent, it may be slightly heavy-handed, and I think it's a function of trying to find a simplified system. But we have this in the US, but with a single patent for a continent. But so there's the enhancement of business certainty is at least the theory, and that it will apply across all participating European member states. And the idea again is to improve efficiency by reducing forum shopping, which again has been one of the difficult. It's been used as a tactical consideration in multi-jurisdictional litigation, and the idea is to sweep that away. And whether it will entirely remains to be seen. And the system will exist in parallel with current national and European patent systems. So for some years, there's going to be a number of options that people might be able to take in relation to getting protection. So the basic framework is that the unitary patent package comprises three parts, essentially. A patent regulation, the unitary patent regulation for the enhanced cooperation procedure. Now, Spain and Italy decided that they didn't wish to participate in this, and they considered it illegal and have sought to block this. And I'll talk about that very briefly in a moment. And then there's a language regulation to seek to simplify the language considerations. And then there's an agreement on the Unitary Patent Court. And both of the regulations have been approved by the European Parliament and then by the European Council a couple of years ago. And they entered into force in 2013. But they become effective when the UPC agreement comes into force. Now, the UPC agreement has been signed by many countries, but there are several that have still not signed it. And it comes into force when 13 countries ratify the agreement, and that must include Germany, France, and the UK. And at the moment, there are 6 countries that have ratified the agreement. So the question is, well, it is going to happen, but when is it going to happen? And the official line is not before the end of 2015, which in good old European fashion is an extremely helpful and clearly unambiguous statement. So we'll be looking at 2025 or 2050 perhaps, but realistically, I think a lot of commentators are taking the view that it's going to be within the 2017, 2018, maybe a couple of years later. No doubt there'll be other political considerations that come into play, but just speaking with a good friend of mine who's involved in the process a couple of days ago, he was of the view that if he had to put money on it, he would be looking at the second part of 2017. But I might have a little side bet with him on that. I think that's optimistic. So what is a unitary patent? As I mentioned, it's a single patent for the European states, and it will be in the French, German, or English language. And it's a single patent, whereas at the moment we have a European patent system where there's a unitary application process. But once you get to grant, your European patent application becomes a bundle of national patents. So you'll have a European German patent, a European Dutch patent, and a European Spanish patent, or Swedish, or whichever countries you so choose. This will simply be just one legal body, legal right. The application and examination procedure won't change. It will be administered by the European Patent Office, and the substantive law will remain the same. So there'll be no cost benefits as regards the application process. And then at grant, there is an option to either retain your case as a standard European Patent Convention patent, and within which 3 months from grant you have to validate the European patent in the selected states that you so choose and file translations. And then transform, the alternative is that one might transform the application to a unitary patent, and you would need to do this by making an application within 1 month from grant. Then the granted European case will be accepted as a unitary patent, and no translation will be required is ultimately the long-term goal. But for a transitional period of some years, if the application has been made in French or German, then an English translation will need to be filed. And if the application was made in English and translation to one other EU language will need to be filed. Excuse me. Ultimately, high-quality machine translations will be available, so that will help in relation to the ensuring that the public across the European Union are aware of what rights are out there. So, as I've mentioned, in the interest of time, I'll just move over this. I've just mentioned this. So, it may well be, because of the fact that there are certain countries that are members of the European Patent Convention but not in the European Union, there are certain European Union countries that may not sign up to this. The unitary patents will cover, at the moment, the 25 member states that have signed up to, or expect to sign up to it. The European patents you might file designating some or all of the non-European EU EPC countries, or some of the opt-out countries. So you might, for example, find that you need to take an alternative route in relation to gaining protection in places such as Spain, Italy, Switzerland, etc. And then there will remain the possibility of obtaining national patents, so Russia, Norway, and one of the considerations on this, because of the uncertainty as to what's going to happen, is whether one might, as it were, double bank by filing say a British national application as well as a European case, or indeed in other countries. And there are all sorts of tactical considerations, and we presently do that for a number of clients for all sorts of reasons. And I think that's going to remain while there's a significant element of uncertainty. So as far as the costs are concerned, there's no such thing as an average size case, but if we take an average size case and you validate it across the nearly 30 European member states, the costs approximately of around 40,000 euros might arise. And of that, a very significant part is attributable to translation costs. So, however, on average, European patents are